For 1640 years, if you got into a street fight or a neighborhood dispute in India, the police and court spoke a specific language. Sections 323 and 324 of the Indian Penal Code were the default vocabulary for assault injuries. As of July 1, 2024, those old numbers are legally dead. This creates an immediate problem. If you walk into a police station today and try to file a complaint citing the old IPC sections, it will be rejected. More dangerously, assuming the old penalties still apply to a physical altercation could expose you to severe financial and legal jeopardy. India is now operating under two new governing frameworks. The Bharatiya Nyaya Sanhita, or BNS, replaces the Penal Code and dictates crimes and punishments. The Bharatiya Nagarik Suraksha Sanhita, or BNSS, replaces the CrPC and dictates the procedural rules of the system. Our objective today is to map the exact equivalence of India's most common dispute laws and break down exactly how bails, fines, and FIR procedures work right now. This overhaul re-engineers the economic and procedural stakes of every street fight and neighbor dispute in the country. Let's start with the most common scenario: a minor scuffle over a parking spot or road rage incident resulting in simple hurt, essentially bodily pain. Under the old system, this was the famous IPC 323. Today, it falls under BNS Section 115, subsection 2. While the maximum jail time for simple hurt remains 1 year, the financial penalty jumps from 1,000 to 10,000 rupees. We see the same multiplier applied to grave and sudden provocation under BNS 122. The old 500 rupee fine is now 5,000 rupees. But despite the massive hike in fines, simple hurt is still categorized as a non-cognizable and bailable offense. This means the police cannot make an immediate non-bailable arrest on the spot. That protection vanishes the second a scuffle escalates. If someone introduces a dangerous weapon into the fight, a stick, a metal rod, or a knife, the charge upgrades to BNS Section 118.1, which replaces the old IPC 324. At this tier, the maximum fine leaps to 20,000 rupees, even if the injury is minor. The new law penalizes the loss of temper with a harsher economic sting. For the aggressor, settling out of court just became significantly more expensive. There's a strict threshold where a fight goes from a costly mistake to a life-altering event. To be charged with grievous hurt under BNS 116, a victim must suffer one of 8 injuries, like a fractured bone or permanent facial disfigurement. But lawmakers added an extreme category under BNS 117.3, injuries resulting in permanent disability or a persistent vegetative state. BNS 117.3 triggers a mandatory minimum sentence of 10 years of rigorous imprisonment, which can extend up to the remainder of a person's natural life. The mandatory minimum is the key here. It strips trial judges of their ability to show leniency based on context. Even for a first offense with mitigating circumstances, the judge has no power to reduce the sentence below a decade. A single unlucky punch with a catastrophic outcome now guarantees a decade in prison. In this legal environment, walking away from a confrontation has become a mandatory survival strategy. Knowing the penalties is only half the equation. We must examine the case initiation process under the new procedural code, the BNSS. In this dual-track flow, entry points have changed. BNSS Section 173 guarantees a victim's right to a zero FIR. They can force any police station to record a crime, eliminating geographical barriers. The trade-off? The accused can now face FIRs logged hundreds of miles away. However, the rules are different if the victim bypasses the police and files a private criminal complaint directly to a magistrate under BNSS Section 223. Under the old CrPC, a magistrate could issue a summons based largely on the complainant's statement. BNSS 223 introduces a new protection. The magistrate must give the proposed accused an opportunity to be heard before taking cognizance of the case. The legal system is balancing the scales. The BNSS simplifies the process for victims to log police FIRs, but installs a procedural hurdle at the magistrate level to protect against surprise, malicious harassment suits. The philosophy of the BNS and BNSS is clear: higher economic penalties for minor offenses and mandatory prison time for severe damage. Let's put this into a practical scorecard to navigate this new reality. First, if you are the victim, stop using IPC sections at the police station. If a complaint is refused, explicitly cite BNSS 173 for your right to a zero FIR. If you are injured, secure medical documentation immediately to see if your injuries match any of the 8 specific categories of grievous hurt under BNS 116. Now, let's flip the perspective. If you find yourself as the accused, if a neighbor tries to bypass the police and take you straight to court over a minor dispute, remember that BNSS 223 protects you. You have the right to be heard by the magistrate before any official summons is issued. Above all, understand the danger of escalation. Drawing a weapon or causing a severe injury triggers non-bailable clauses and mandatory minimums that bypass judicial flexibility. The era of the casual street fight is over. You either walk away or you pay heavily in cash or years of your life.